Class is now in session. Today we'll talk about the arrest and post-arrest procedures for juvenile offenders. In the state of Michigan, juvenile offenders are those offenders who commit a criminal offense at a time that they're under the age of 17. There are three general categories for offenses for juvenile offenders. The first is status offenses. Status offenses include charges such as runaway, where a child runs away from home without the permission of their parents with the intention of staying away. The second is truancy. Children are obligated to go to school, and when they fail to do so on a regular basis, they can be charged with truancy. The third is incorrigibility. And incorrigibility is a child who chronically refuses to follow the reasonable commands of their parents, such as abiding by a curfew or the people they tend to associate with. Juvenile offenders can also commit offenses known as misdemeanors. The Michigan legislature has prescribed that misdemeanors are those offenses which, if committed by an adult, would be punishable by up to a year in jail, but not more, and or a fine. An example would be assault and battery. You hit someone with a closed fist intentionally and without their consent. This is assault and battery. It's punishable by up to 93 days in jail and or a $500 fine. However, for a juvenile offender, depending on the makeup of that child, their mental health, their emotional health, a court could decide to keep them under the jurisdiction of the court up until their 19th birthday. So that literally means a 12-year-old who commits an assault and battery could face far more than an adult offender would for the same offense. That's one of the differences between the two systems. The third category is felonies, and the Michigan legislature has prescribed that felonies are those serious offenses that carry more than 1 year of incarceration. As an example, hitting someone with the baseball bat, not by accident, but intentionally and without their consent, is known as assault with a dangerous weapon and sometimes referred to as a felonious assault. Again, if a child commits it, they could be kept under the jurisdiction of the juvenile court up until their 19th birthday. Police officers have the authority to use discretion. Discretion includes things as to arrest or not to arrest. They could warn and release an offender as opposed to arresting them. So, for example, you get stopped for speeding by a police officer. He or she asks for your paperwork and your license, and even though you were speeding, they decide to give you a warning and not to issue a ticket. Police officers have that discretion. The same with juvenile offenders. They can warn and release a juvenile offender, keep track of their name, and if they get in trouble again, decide, do I warn and release again, or do I seek formal charges against them? Police officers have this discretion. But they also have the right to arrest. They have the right to perform an arrest within their own jurisdiction. What does that mean? Let's take the City of Adrian Police Department. The City Police in Adrian have the right to arrest offenders within the confines of the City of Adrian. Likewise, the Lenawee County Sheriff's Department has the right to arrest offenders within the confines of Lenawee County. And of course, the State of Michigan Police, the Michigan State Police, have the authority over the entire state of Michigan, regardless of which post they're assigned to. What about the arrest of status offenders? The police can arrest a child for being a runaway, a truant, or incorrigible child. However, the state of Michigan and many other states looks upon these types of quote-unquote offenders not as offenders, but as in children in need of services. The reason for that is that many of our experts have discovered that the reasons why a child might run away or be a truant or act out and be an incorrigible child is because of some type of neglect or abuse that they're facing at home or elsewhere. So for instance, a truant may decide not to go to school because they're bullied, or their parents intentionally withhold them from going to school because they're afraid a teacher is going to notice the neglect or abuse suffered by their child and report them to the authorities. These type of children do not need to be punished. Instead, what they need are services. So upon arrest of a status offender, the police are not allowed to detain the person at a detention facility, such as a detention facility for young offenders. If they were to do that, the facility faces the threat that the federal government will withhold funds, because the federal government also understands and recognizes these are children in need of services and not to be quote unquote punished. However, there's an exception. If a judge orders a child to go to school, or to not run away, or to follow the reasonable commands of their parents, and the child violates that court order by not following the court order, they can be held in contempt of court. As a result of being found in contempt of a court order, a child may then be detained at the juvenile facility, even though otherwise it might look like they're being detained as a runaway, a truant, or an incorrigible child. In truth, they're being detained or quote-unquote punished for the violation of a court order. What about the arrest for misdemeanors? In order for a police officer to be authorized to arrest someone for a misdemeanor, the misdemeanor must be committed within their presence. That is, the police officer witnesses the event. If the police officer witnesses someone with a closed fist intentionally hit someone, and that person takes offense to it, the police officer can conclude, based upon their training and experience, that they've just witnessed an assault and battery and arrest the offender. If it's not in their presence, they should maintain the peace, separate the parties, take information from witnesses, file a police report, and await the authorization of a charge or charges from the local prosecutor. If the prosecutor chooses to authorize the charge, an arrest warrant will be issued. Any police officer with the knowledge of the arrest warrant may arrest the offender. There's at least a couple notable exceptions to misdemeanors that would subject the offender to an arrest without being committed in the presence of the police officer. The most common is domestic violence. Someone assaults and batters a sibling, a parent, someone they've dated or are dating or have lived under the same roof, considered a domestic partner. Our law and our policy recognizes, to avoid further harm or even death, that police officers can arrest based upon reason to believe that domestic violence was committed, even if it wasn't in their presence. The other common one is retail fraud, better known as shoplifting. If they have reason to believe someone shoplifted, they may arrest that person. Otherwise, if it's not in their presence, they must file a police report and attempt to get an arrest warrant. What about felonies? Felonies are a little bit different. As you might imagine, the law recognizes that people who commit serious offenses such as felonies, we don't want them to get away with that serious offense. And so the law permits the police officer to arrest somebody based upon probable cause. That is, reason to believe that a felony was committed or is being committed. As an example, a police officer hears someone scream and pointing to someone running away with a purse. That man just stole my purse. Based upon the officer's training and experience, they could conclude that this person just committed a felony, and they can pursue the individual to attempt to arrest them. They also have the discretion, though, to not arrest, to maintain the peace, to take down a police report, gather the information, and ask the local prosecutor to authorize an arrest warrant for that felony. Here on this particular slide, you see the different levels of required proof, and then one we're talking about right now is probable cause. What about post-arrest? And now we're going to focus on juvenile offenders. In the state of Michigan, they have something called the immediacy rule. And what the immediacy rule means is this: upon the arrest of a juvenile offender, with or without an arrest warrant, the police are obligated to take that child forthwith, meaning now, in front of the juvenile court judge. If she or he is unavailable, they're to take the offender to the juvenile detention facility. If that county does not have a juvenile detention facility, the police officer has the authority to take that offender to the county jail. However, they must keep that child out of sight and sound of adult offenders. To do otherwise violates the law, and you risk federal funding. You probably can understand and appreciate why you want to keep a youthful offender, especially a first-time offender, away from adult inmates. It would not be a good influence on them. There are some exceptions, however, to the immediacy rule. For instance, there's a number of Michigan court cases, that is, cases handed down by the Michigan Court of Appeals and or the Michigan Supreme Court that has interpreted the law and even the immediacy rule to say whether or not the police can do certain things other than to take the child forthwith to the juvenile court judge or to the juvenile detention facility. And that is as follows. They may take a juvenile offender to the county jail for purposes of taking mug shots and or fingerprints. However, they cannot take a confession. If you take a confession at the county jail, it is likely subject to be suppressed. That means that it will not be admitted as evidence in a courtroom. You might imagine that if something's not going to be admitted in the courtroom, you might not be able to make a case. So no evidence, no case. In fact, if a confession is taken illegally, any information the police find out, like where to find other evidence, can cause that evidence to be suppressed or withheld as well. Now, admissions is a different story. I think everyone understands what a confession is. You've heard of Miranda rights. The police officer gives you your Miranda rights, tells you have the right to remain silent, the right to an attorney, and that if you do speak, that anything you say can be used against you in a court of law, so forth and so on. That is the indication that a confession is about to be taken. However, an admission is a different story. While taking the juvenile offenders' mugshots and fingerprints, if they blurt something out like, yeah, I hit him and I'm going to hit him again when I see him, that would be a damaging admission against the interests of that juvenile offender. That statement was not extracted by the police in an attempt to get a confession. They were simply doing the mechanical application of trying to get a mugshot or fingerprints, and the offender blurted it out. Admissions can be used against that offender. To be sure, though, the defense attorney on behalf of that juvenile offender will try to challenge even that statement in court and try to get it dismissed. So we talked about motions to suppress evidence. Motions to suppress evidence are filed by defense attorneys on behalf of their clients. If someone violates the immediacy rule, the defense attorney will attempt to have anything that was gathered illegally thrown out of court. This again is called suppression of the evidence. And again, if you don't have sufficient evidence to prove a case beyond a reasonable doubt, the case is going to end up with a verdict of not guilty. But worse yet, on a motion to suppress evidence, if the court grants it in advance of trial, which is when it will be heard, there's a good chance the prosecutor will dismiss it on their own, knowing that they can't prove the charge beyond a reasonable doubt. So again, fair warning to the police, you want to be very careful about taking statements improperly, lest you have that evidence suppressed. This includes charges all the way up to murder, and there have been real-life examples that we'll discuss later where that has happened. So now, having heard all of this, if you want to find out more information, you can go to the Michigan Judicial Institute. There are a number of bench books there that judges use to help them find answers about the law. It's a really good resource on laws, court rules, and cases. You can find it at mjieducation.mi.gov. Find the bench book on juvenile justice, go to Chapter 3, and you can learn more about the arrest and post-arrest procedures for juvenile offenders. When you get a chance, take a look at these list of questions, and let's see how much you got out of today's presentation. Thank you for taking part. We're adjourned.